Good afternoon, everyone. We'll just give everybody a minute or so to join before we kick off. Thank you. So hello, everyone. Welcome to our webinar, hosted in partnership with Voice Turner. I'm Stephanie McCleary. I'm a director here at Fraser Jones, and we're a global HR executive search and recruitment consultancy. I lead our commerce and industry recruitment team. We place exceptional HR professionals within businesses from startups through to global FTSE organisations across the permanent and the interim hires, and not only across London and the home counties, but we've also got a global reach covered by our 14 offices worldwide. I am very pleased to welcome Emma O'Connor, Legal Director and Head of HR Training at Boyes Turner, a leading full-service UK law firm. As HR professionals, you know the pace of employment law does not stand still. And today, Emma is going to talk to us through potential employment law changes in the UK, how they may affect HR in your business, and what you can do to stay ahead of the game. We don't have a crystal ball, but so many of the HR community are keen to get an understanding on what we are likely to see at the end of the year and into 2024. So this snapshot today is a flavour of the direction of travel we are heading towards. We are live today and we'll do our very best to answer questions in the chat as we go through the session. But without further ado, I'll hand over to Emma.
Thank you very much, Steph, and thank you so much to Fraser Jones for asking me to come and host this webinar today. I think it's fair to say that the response has been amazing, and it's great to see so many HR professionals joining us today. So Boyes Turner, yes, we are a full service law firm, as Steph has explained. We look after clients in the UK, across Europe and also globally. In the employment team, we assist clients with their HR, day-to-day HR advice work. We also look after employer clients with their litigation. We have a thriving business immigration team as well. And I head up our HR training arm, which basically means that I help managers and HR teams with their training, deliver training, and in particular legal compliance training on how you manage disciplinary grievances and also on EDI. As Steph said, we are live. Please do post any questions that you have. We will do our best to answer them as we go through the session, but always happy to come back and assist where we can. This is an overview, so as always, please do ask any specific questions separately and we can come back. So without further ado, let's have a look at what is going on in the world of employment law and employment legislation. Well, as many of you will know, April is the sort of key month for HR and employment changes, and this April was no exception. So what we see in April are changes to statutory pay in particular. So we saw a rise, as we can see there, in statutory sick pay, also in the statutory minimum pay that employees receive when they are on family leave. Key points there to note are obviously make sure that you are paying employees correctly. And also, as we see those rates increasing year after year, it's also a good opportunity to have a look at your own company policies as well, and to make sure whether that they are actually in line with the statutory regimes as well, whether there needs to be some tweaks in terms of what it is you are offering. April as well is also when we see changes to the national minimum and national living wage. So again, we saw an increase here on the rates that we saw in 2022. National minimum wage is obviously age related. So it's always worth taking those steps to really audit exactly the ages of your staff. For example, when they might be clicking into that, 2020, 22 to 23 age bracket. Also to keep an eye on your wage bill as well. If you've got a huge spike of birthdays in one particular year, then obviously that's going to have an impact on your wage bill. So it's always worth just keeping a check on auditing your staff, and also making sure everybody is paid correctly, because the eagle-eyed amongst us will have seen an announcement last week from the government about the number of businesses who have failed to comply with the national minimum wage and national living wage rules. Now, those payments are mandatory, and as well as being legal implications in terms of not paying the correct national minimum wage, we also see this naming and shaming of organisations. And those of you that have, looked at the press or read the report that was issued by the government, there were a number of high-profile, high street names that have been found not to have been paying the national minimum wage. Now, what I will say about the naming and the shaming, and also compliance more generally, the rules around the national minimum wage are incredibly complicated. They are not an easy set of laws to navigate, primarily because there are lots of things that employees are either paid or not paid or receive, which don't count towards the national minimum wage. So things like accommodation, things like uniform costs, equipment costs, etc. So they are very, very complicated. So what I would say is, if you are looking at your wage bill, you are looking at the national minimum wage and thinking, where on earth do we start? Then do get in touch, because we're helping a number of clients with this particular issue at the moment. So as well as April being, statutory changes, there are also changes that we see with regards to employment tribunals, and in particular compensation figures. Now, the maximum claim there, as we can see, for unfair dismissal compensation, this is the maximum award, has increased to £105,000 and 707 there. So that's the maximum award, or it is 12 months pay. Whichever is the lower amount. So I think what I would be saying about that is, when I started as an employment lawyer 20 odd years ago, the rate there, the higher rate there, was about £11,000. So you can see in that time period how much the rate of compensation, that maximum rate of compensation, has increased by. Quite phenomenal, really. The other point to remember is that they are for dismissals that took effect on or after the 6th of April this year. So those of you who are making dismissals now, these are the sorts of rates that you are looking at. The other important figure there is the rate of a week's pay. Now, the rate for a week's pay is what we use when we calculate the basic award. Again, when we're looking at that statutory right not to be unfairly dismissed. But we also use a week's pay when we're looking at calculating statutory redundancy payments as well. So for those organisations who are looking at their workforce, looking at workforce planning, then that's the week's pay that you will be taking into account when you are looking at the statutory right there, the statutory right to redundancy pay, where you have employees who've worked for you for 2 or more years. So these payments are significant, particularly with workforce planning. I think they're also significant because when we think about the rates involved, particularly for unfair dismissal, it's worth people in certain circumstances actually bringing claims. Potentially, there is a lot that they can win from bringing employment tribunal claims. So it is significant. And I think, again, it reinforces that message for employers around policies, making sure that our policies are up to date, making sure that our policies are communicated, not just to managers, but also to wider employee populations. And also making sure that our managers know what to do with the policies and the procedures. So making sure that they're trained, making sure that they get things right. So again, it is one to really sort of focus on and remember that, those are the figures, and, training your managers, getting your managers up to date, training them on the processes and procedures to make sure that they get things right. So we don't find ourselves in situations where we are having to face employment tribunal claims. I've had a question here about the statutory severance calculator. There is a very useful what's called the Ready Reckoner calculator on the government website. If you just type into a search engine, government redundancy Ready Reckoner, it's a very useful way of going in there and actually calculating. And what that will do, because the statutory redundancy pay is based on your age, how long you've worked for your employer, at certain ages, and obviously on your weekly rate of pay. So if an employee earns more than the statutory weekly rate of pay, then you use the statutory rate. If they earn below it, then you use their actual earnings. But the government website there and that ready reckoner is really useful. Obviously, there are points around, particularly when you think about redundancy, you may have company enhanced schemes as well. So again, it's making sure that you incorporate those statutory rates into any potential company policy or company scheme that you have. Now, I've been talking a lot about employment law, and one of the things that I was talking about way back in 2019 was the employment bill, the much heralded part of the then Queen's speech, which talked about all these employment law changes that we would expect to see. However, fast forward to 2023, and it's very much that the employment bill as was is no more, and is very unlikely to be resurrected from the long grass which it appears to have found itself in. But what we have in place of the employment bill, so that all-encompassing bill, is several private members' bills, so parts of the employment bill that have been picked up by various members of Parliament and currently going through, and some have received royal assent, part of that sort of employment bill, that legacy. And one of those potential changes that we may see and is currently going through Parliament are changes to the flexible working regime. Now, as we know, we have universal flexible working, and that means that employees, for whatever reason, provided they have 26 weeks of continuous service with you, can make the statutory request to work flexibly, remembering, of course, it is the right to request flexible working, it is not the right to work flexibly. We also used to have a rather rigid regime where you had to do certain things by certain time frames, or write letters within 14 days, etc. We don't have that anymore. We do have an ACAS code of conduct, which means that employers have to deal with flexible working requests in a reasonable way, but they have to be dealt with within 3 months from the date of receipt to the date of appeal, if you get to an appeal. Currently, employees are entitled to make flexible working requests once every 12 months. And also, once those changes come into effect, then they are a permanent change to the employee's contract of employment. So what is proposing to be changed? Well, it is proposed that employees will be allowed to make 2 requests per year. There will be a shortening of the process from 3 months to 2 months, and also a change that employees now will not have to explain to their employer either why they think the change will work or won't work, or what processes could be put in place to allow the change to work. So it's really putting the emphasis back on the employer. Now, the big headline is that the right to request flexible working will become a day one right. So rather than employees having to wait 26 weeks, they will be able to do so as pretty much they open the door to your office or place of work. They can request to work flexibly. And remembering flexible working, it's looking potentially at hours, potentially at days of work, potentially location. So there's lots of things that can count as flexible working. But there is a shift, isn't there? There is going to be a shift with changing the presumption that, flexible working is a day one right. So I think that's really going to put pressure then on managers and recruitment teams when they're looking at jobs, when they're looking at where they're going to recruit, how they're going to recruit. Can roles be worked in a flexible way, and almost sort of preempting what a potential successful candidate may ask for? Now, we have to remember that it is, as I've said, the right to request. We will still have the 8 statutory grounds for which to be able to refuse a request. But of course, that's becoming more difficult because, the sort of the points in there about inability to recruit or, inability to be able to swap work around teams is becoming harder and harder as we see more and more jobs either being worked in a hybrid way or a remote way. So I think it's going to become harder for employers potentially to be able to justify, and of course remembering all those other risks around discriminatory risks as well. So I think flexible working, the potential changes to that, we don't know if it's going to be passed, hasn't been passed as yet, so it's very much watch this space. But I do think, you know, the direction of travel is very much focusing on flexible working and how we can make that all work. Now, another private members bill that has actually received royal assent is looking at the extension of redundancy protection. Now, at the moment, women who are on maternity leave or parents who are on adoption or shared parental leave currently have protection under the current law, which states if their role is placed at risk of redundancy, then they rank higher, if you like, in terms of being able to be offered suitable alternative employment. And as we know, offering suitable alternative employment is part of those obligations. You know, we're looking at consultation, et cetera, et cetera. So they will rank higher than other individuals within that at-risk pool. Now, many employees unfortunately find themselves in a situation where they return to work only to find that they are then you know, placed at risk, etc. So there's been research done which says that some employers will in fact wait for employees to return from their family leave before making decisions with regards to redundancy, that, you know, therefore trying to avoid the current level of protection. Now, under the Protection from Redundancy, Pregnancy and Family Leave Act, which has been given royal assent, though that protection is going to be extended, and it's going to be extended to female employees once they tell you and notify you that they are pregnant. It's also going to remain for individuals who are on maternity leave, adoption leave and shared parental leave, but it's then going to be extended for a period of time. As yet, we don't know, it's not actually in the current version of the Act. However, it's suspected that those individuals will then be protected for a further 6 months when they return from either maternity, adoption or shared parental leave. So potentially there a very long period of time, you know, that individuals could potentially, you know, benefit from this level of protection. Now, there's obviously some issues here. Knowledge, you know, what's knowledge going to be of an individual's pregnancy? Is this potentially going to put pressure on women to tell their employers earlier that they are pregnant to receive protection? So some issues there. Also some issues around shared parental leave. You know, shared parental leave, as we know, could be for as little as a week. So does somebody taking shared parental leave for a week then qualify for that 6 months potentially of protection when they return? This may encourage more individuals to actually take shared parental leave because the take-up has been, you know, historically very low. So there are lots of questions here around the mechanics of how this is all going to work, and also about, you know, how employers are going to manage their redundancy programs and making sure that they are aware exactly who is returning from what leave and making sure that individuals receive that level of protection. Now, with these private members bills, what's actually happening is that, yes, they may be getting royal assent, and as we can see, this bill here has received royal assent, but the actual enabling legislation, so the law that's actually going to bring this stuff into being, then has to be passed. So the actual detail of all of this will then be in secondary legislation. And as yet, we don't know when that's going to come before Parliament. Obviously, you know, Parliament only has a certain amount of time to be able to hear things. And then obviously there will be an implementation date after that. So at the moment, it's something that, you know, there is an intention for it to happen. When this will happen, we don't know. And similarly for carers leave as well, again, this is one of those private members bills, as I've mentioned, that has received royal assent. So essentially the premise of this is that employees who have caring responsibilities will be able to take 5 days, up to 5 days per year, unpaid, to allow them to facilitate their caring responsibilities. Now, caring and those responsibilities and who individuals care for is probably going to be looking at those definitions we already have when we think about dependent leave. So it'll be, partners, husbands, children's parents, etc. At the moment, as I've said, we're waiting to understand what the actual mechanics of this will be, but essentially it will be on the basis of self-certification. So it will be where individuals will self-certify to say, yes, I have caring responsibilities. These are my responsibilities, and this is, therefore I'm requesting the leave. But at the moment, that leave will be unpaid. So again, something to watch out for. When this may actually come into being, we don't know. So again, the mechanics of it will have to be determined in subsequent legislation. But I think it gives you a flavour of where the kind of direction of travel is going. Neonatal leave and statutory neonatal pay. Again, this is something that has actually gone through Parliament. However, it may not be until April 2025 until we see any actual legislation for this. But in essence, what the proposal here is that parents of children that require neonatal care at birth will be entitled to take up to 12 weeks of neonatal leave, and also subject to eligibility requirements, which will be similar to what we see for statutory maternity pay and statutory paternity pay. That will be, they will receive also statutory pay, statutory minimum pay during any period of neonatal leave. Now, what's interesting about this leave is that it will be tagged on to existing leave. So, for example, potentially a mother whose child needs neonatal care could be looking at maybe taking as much as sort of 15 months off of work. So if we think about our planning, if we think about recruiting, if we think about, how we can cover someone's leave potentially, it might be that we need to think flexibly in terms of how we can make those plans work. So I think there are some sort of issues there that employers will have to think about, particularly around the communication with employees who do go off on maternity leave, etc. So some planning issues there and some communication issues there. Just going to check the chat. We've just had some chat there. A couple of questions there. So Kim, thank you for yours. And I will deal with that offline if I may do. Thika, thank you for yours. How long will they be entitled to neonatal leave? At the moment, it's looking like up to 12 weeks. But again, that's something that may change between this interim period of the Act passing and the actual enabling legislation coming into place. It's looking likely, Laura, it will be available for both parents. So again, it's just kind of watch this space, I think, with that one. So yeah, Simran, yeah, it isn't in addition. At the moment, it is proposed it will be in addition to rights existing individuals already have. So as I've said, there's a lot of planning there in terms of, making sure we've got the right recruitment in place for individuals who do go off. So yeah, I think, you're absolutely right. There's lots of issues, particularly with this type of leave. So I think we'll have to just wait and see what comes out in subsequent legislation. But again, it's about supporting employees. And again, I think that's the real flavour of what we're seeing coming through. And again, supporting employees, supporting workers, those of you who are listening who are in the leisure and hospitality space, tips and gratuities have been, an issue for a long time. And what we have seen now is legislation that has actually been passed to look at and actually, legislate for employers directly passing on those service charges, those credit card tips to their employees and to their workers. So we're looking at that fair distribution amongst staff. Now, it is only for those payments that employers have control of. So it's not cash tips, monies in jars, etc. It's the service charge. It's the bit that is added on to a customer's bill. So essentially, employers will have to have a fair distribution. So how are they going to allocate tips amongst waiting staff, maybe kitchen staff? How is that all going to work? They're going to have a policy on that. And also they are going to have to disclose how they allocate tips if they are asked to do so. So this policy is going to be very important for employers to get right. A lot of employers are doing this anyway, in my experience, but what we're doing is we are waiting for a code of practice to come up, which is really going to explain how employers can do this. I think the other flip side of this is obviously thinking about, you know, staff that do work in leisure and hospitality, and actually now their tips are going to be part of their wages, and they will have to pay tax on them, income tax on them, and, you know, an employee NI. So there are a lot of other kind of unintended consequences of this legislation. So it's going to be very, very interesting. We're going to see employees wanting to reduce their hours if they are in receipt of benefits. How's that all going to work? How is that going to help our businesses in the leisure and hospitality industry, which struggle with recruitment more generally? So I think there's a lot of issues around this piece of legislation that I don't think have really been thought of. And speaking of unintended consequences that perhaps haven't been thought of, that leads me rather nicely to talk about the Prevention of Sexual Harassment bill that, again, many of you may have read about or heard individuals or lawyers talking about. And this was one which, you know, in theory, absolutely brilliant. It puts the whole issue of workplace sexual harassment, you know, back up there on the agenda. You know, absolutely fantastic. This positive duty for employers to stop, you know, workplace harassment. Who isn't in favour of that? However, part of this proposed bill was to basically put that obligation back onto employers to protect employees at work from harassing behaviours from customers and clients. And remembering that the definition of harassment under the Equality Act is that feeling of intimidation, of having that workplace which is hostile and intimidatory, and really that was placing a lot of pressure, particularly again on employers in that leisure and hospitality space. They were effectively going to have sort of, you know, speech bouncers, stopping, you know, conversations that their staff may find offensive, and creating that hostile environment. So at the moment, that bill, whilst if you look on the government, if you look on the legislative website, it will say that it's still sort of slowly winding its way through the parliamentary process. I think what will happen is it will simply we will simply run out of time. I think that, you know, when Parliament runs out of time, then this bill, rather than there being any suggestion that it has been cancelled, I think there will be an issue around, you know, this will simply not go any further. And Mark, I completely agree with you. It's surprising that nobody thought about that before it got this far. Other possible changes that may be coming through. So hiring and refiring, or firing and rehiring, hiring and firing. Basically, this is the practice of employers wanting to change terms and conditions of employment. And when you're changing those fundamental terms and conditions of employment, as we know, we cannot do so without the employee's consent, because to do so would be a unilateral variation entitling the employee to resign and claim, if they are eligible to do so, constructive and fair dismissal. However, what employers can do is, if they have consulted, negotiated, complied with any legal obligations that they need to, collective consultation, if there are the potential numbers there, then what employers can do is they can fire under the current contract, remembering to give notice, the correct notice under the current contract, and then rehire, well, fingers crossed, under the new contract. The idea there being that the employer will say as well, employee, you have no loss because we've offered you the job. You're essentially your same job back. And some of you may have seen that Tesco's have got into a bit of bother about doing this with the unions. It's one of those practices the unions don't like. So there is a proposed code of practice, an ACAS code of practice, looking at the practice. So it's not going to be banned, but what the code of practice is doing, or the proposed code of practice, is basically getting employers to do it in a reasonable way. So ensuring you've got adequate communication, notice, etc., etc. So it is one to watch out for. And again, if you're looking at making changes to terms and conditions of employment, particularly when they are those fundamental terms, then please do get in touch, because there are some little hidden issues there that might come back to bite. Again, strike legislation, we saw the banning of agency workers being lifted last year, but this idea of having minimum service levels, particularly for those who are in health sector, obviously sort of, you know, various public sector jobs, border security, etc., etc. So ensuring that those individuals, whilst they can strike, making sure that you've got those minimum levels of service to the public. Again, it's going through who knows where we may or may not get to in terms of parliamentary time, and also parliamentary appetite as well. A lot of this depends on, you know, whether you know, governments want to sort of push forward these bills. So again, it's something to watch. And also about retained EU law bill. Again, this was one that was sort of heralded as the sort of the Brexit bill that would basically be a bonfire of all of much of EU law that we've retained. Much of those are the regulations, so things like you know, the working time regulations, agency worker regulations. And so the idea is that at the end of this year, or maybe June 2024, if in time needed to be extended, there would be this sort of, you know, review. And it was very much, you know, if you lose it, you know, use it or lose it type scenario, where, you know, if you wanted to keep, the government department wanted to keep the legislation, great. If it didn't, then it would automatically be repealed. The new business secretary has said that that's not now going to happen. There's going to be a much more measured approach, and much more targeted approach, rather than this sort of, you know, cliff edge where everything would come to an end. So, you know, perhaps a lost opportunity to have a look at some of the laws. I know particularly, you know, the agency regs are ones that you know, employers don't like. So who knows, I think we'll have to kind of watch this space, but certainly the proposal of that kind of December cliff edge is no more. So that's a kind of an overview as to what changes that we've seen over coming months, and what changes, you know, we might look to see in terms of what we might look to see in the coming months. Just having a look at some of the questions there. Yes, this session is recorded, so you will get a link to that, Serena, don't fear. So yes, that's Steph, that's over to you.
Fabulous. Thank you so much, Emma. That's really, well, loads of information. I'm sure we can all agree that we've learned a huge amount from Emma to take away with us today. Emma, what do you think some of the things employers can be doing now to get ahead?
Yeah, no, thanks. Thanks, Steph. I think the first thing I'd say is look for opportunities. I think that particularly when we think about recruitment, and when we think, actually probably more importantly, around retention, I think there are some things there that we've seen that are potentially coming up that employers may want to, you know, sort of grasp now. I'm thinking in particular about carers leave. that may be something that employers want to, you know, consider introducing. Now, you know, particularly thinking about the demographic of your workforce as well. There's a big drive at the moment to get, you know, individuals who are kind of, you know, over 50s, over 55s, you know, keep them in the workplace, that great wealth of talent that we have. And encouraging people to stay. So maybe have a look for opportunities. I think the other point is, you know, when we think about, you know, tribunal claims, when we think about compensation, when we think about all these new rules that are potentially, you know, coming at us, I think it's important more than ever to make sure that we have a management population who is engaged with people-related issues. And again, you know, a great way to do that is to get them skilled, to get them, you know, trained, to get them really knowing where things are, knowing where policies are, knowing when they might have to hold a meeting, know when they might have to have a conversation with an individual, you know, particularly when an individual's going off on maternity leave. You know, top tip number one, don't panic, you know, but have those conversations with staff. So I think, you know, opportunities there for sort of, you know, legal compliance and knowledge, particularly around that area of equality and diversity. And I think the other sort of, you know, point to note in that direction of travel is that, you know, I'm talking to a lot of HR teams and to a lot of businesses who are now looking at a bit of a kind of a working reset. So, you know, things that maybe worked 2 years ago maybe aren't working now. So is there an opportunity to look at how things are going? You know, particularly when we think about, you know, hybrid working or remote working, is that kind of working for your business? Are there things you want to change? You're thinking about then actually the other sort of spectrum of the workforce, you know, our new recruits and our, you know, and our juniors, are they getting the support that they need, you know, particularly as they kind of move through their careers? So, you know, there are things that employers can be doing now to, you know, to recruit, to retain, to stay ahead of the curve. And I think really to have that period of reflection.
Fabulous. Thank you. So much to take away there. Thank you. And thank you everybody for attending. We really do appreciate it. We can see that, gosh, this has been one of our record webinars with attendees. Clearly everybody finds this topic interesting and useful. We will, as Emma said, we'll be uploading a replay of our webinar today on our website, fraserjones.com. We'll also be sending out a feedback survey, which will include an option for you to give us suggestions on the topics you'd like to hear about in the future. We're going to be running a series of these employment law webinars. The next one's planned for autumn, so watch this space. Dates will be announced in the next month or so. And if you've got any questions in the meantime, please do feel free to reach out to either myself or Emma directly. Details are on the screen here. Again, thank you so much for attending. Take care, have a lovely afternoon, and look forward to seeing you soon. Thank you. Bye-bye.
Thank you. Bye.